Here's the thing. I'm not sending him to lifetime recovery. He is going to safety, or either if felony drug court accepts him, he can be at felony drug court, but he is not going back to lifetime recovery.
Welcome to the trial time verdicts.
Court is calling 2022 CR 6397, State of Texas versus leniency. I have parties announced for the record for the state.
Jason Garahan, Your Honor.
Defense.
Jeffrey Martinez.
And are you Selene Duarte?
Yes, ma'am.
Did you review the document entitled motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Selene Duarte who was placed in community supervision in 2022 CR 6397 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on September 26, 2022 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition number 2 on or about the 5th day of January 2023 in Bexar County, Texas. Defendant Selene Chelsea Fuente did then and there legally use a controlled substance named methamphetamine. Violation of condition number 2.
How do you plead to that? True or not true?
Your Honor will waive the remaining violating conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true and sentence you up to 8 years in the prison and up to a $1,500 fine?
Yes, Judge, I understand.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
All right, court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor. And it is to deny the motion, continue the individual on her probation, and to have an alternate end to order evaluation for felony drug court. If that is not satisfied, or rather if she doesn't qualify, order SATF or SATA.
Do you want to raise your right hand, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Selene Duarte.
All right, why are you not doing well on probation?
I was involved with the wrong person, and I was just making a whole bunch of mistakes that I do not plan on making in the future, ma'am, and I do want to better
Mistakes,
myself.
choices.
No, no.
There were choices.
Yes, they were my choices.
All right, so you're not making mistakes, you're making choices. Why are you making bad choices?
I have no excuse for them, Your Honor, but I do plan and doing good, better choices. I want to do better, Judge. And I need help, and I'm working out. I would like to do anything I can to help work on myself. I'm willing to do the rehab. I'm willing to do anything to just better myself, not just for myself, but for my kids and my family.
All right, so there's been a previous referral to felony drug court. I cannot read the handwriting of the judge who wrote this.
Judge, I'll look into that, Judge.
Judge, she met the criteria, but she had a pending case in the county court, which that's why they denied her. So she needs to intensive outpatient treatment.
All right, and the county court case, has that been taken care of?
Sir, look at that, Judge. Sorry, did not check.
Do you have any open cases?
No, ma'am, I have no cases right now pending or anything.
So the county court case, has that been taken care of?
I believe so, yes.
All right, we're gonna look it up and see.
It looks like she doesn't have any case, except for her FTR.
Hoping you will do well. I don't know if you'll do well. Your track record, it appears that maybe you're not gonna do well. So I'm gonna give you a choice. Here's your choice. I can sentence you to 3 years in the prison, or either I can continue you, but you're not gonna be released from custody unless you're in felony drug court or you're going to safety.
I pick either one of those?
No, what's gonna end up happening, I'll refer you to felony drug court.
Yes, ma'am.
If felony drug court is full, or if they do not accept you, then you're going to safety.
Okay, yes, ma'am.
So
Thank
is
you.
that what you're asking for?
Yes, please. I would like to do the program, one of those programs.
All
Yes.
right. So I'll deny the motion alternating conditions to include, referral to felony drug court. If not accepted, then safety. Defendant is to remain in custody until transfer to safety or felony drug court. Do you have any children?
Yes, ma'am, I have three.
What are their ages?
A 14-year-old, an 8-year-old, and a 3-year-old.
And who do they live with?
Right now they're staying with my grandmother.
All right, your grandmother?
Yes. And my girls are staying with my grandmother and my son is staying with, his family.
All right, is Child Protective Services involved?
No, ma'am. They're not in my custody.
I'm sorry?
They're not with me.
No, but did you?
Oh, they were at one point, yes, ma'am. Yes, they were.
So we're gonna do CPS compliance. If applicable. Were your parental rights terminated or anything?
With my son, yes, while I was incarcerated, yes, ma'am.
Okay, so what were you incarcerated for previously?
I was incarcerated for a robbery charge.
So we'll do CPS compliance. There's gonna be proof of employment,
Yes, ma'am.
45 days upon release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until further notice. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once those are completed, the community service hours will be deemed satisfied.
Yes, sir.
There's to be regular reporting by Zoom or in person. There's going to be the UA hotline upon release. And field visits one time per month upon release
Check one.
for 4 months. And 120 sober meetings in 120 days. Probation, is there anything else?
Okay.
Is there anything else you need from the court in order to be successful?
No, ma'am. Thank you. I appreciate it.
All right, you're welcome. We can go off the record. So here's the thing. The previous judge just ordered for you to be on probation in community service hours and referred to felony drug court. So I'm adding what should have been added, or what I think not should have been added, I shouldn't say that, but what I think should be added.
Yes, ma'am.
So just in case, if you didn't know you were supposed to report bravery once a month, that's why I added it, so you'll know, because I didn't see it written on the docket sheet. But I know that your rights have been terminated to one of your children,
Mm-hmm.
so that means that the rights haven't been terminated to the other two. You still have a chance to get your life together, perhaps be in their life.
Yes,
You
ma'am.
understand?
Yes, ma'am.
But do not, this is my advice to you, do not go out there having more children or getting involved in a relationship until you get your life together.
Yes, ma'am.
And once you get to your life together and see clearly, guess what? You will attract good people. All right?
Yes, ma'am. Thank you.
You're welcome. If you have a question, be sure to ask probation. If you feel as though they're not addressing it, you can always come back to court, okay?
Okay.
And if you graduate from felony drug court, I'll be at your graduation.
Thank
All right? Good luck.
You judge.
Court is going to call 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state? Defense.
Amir Memorial, Your Honor.
And are you Mr. Lewis?
Yes, Your Honor, I have.
All right, Mr. Lewis, did you review the document counsel, you're on this side.
Sorry, Judge.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Mark Daniel Lewis who was placed on community supervision in 2022 CR 8453 for the offense of unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State.
Violated condition number 4 in Bexar County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to report to the supervision officer as directed for the months of October and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
No objections.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 6 years in the prison?
Yes, Your Honor, I do.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor, I do.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, I think that the state's gonna make one recommendation and the defense is gonna request something else.
All right,
But the state is requesting state ISF followed by gang/ISP, and then to hold GPS and SOMU in abeyance.
all right. And defense, what are you requesting?
Judge, couple of things. Mr. Lewis understands the seriousness of what he's facing, Judge. In the state ISF, my understanding is where he got into trouble before, correct?
Yes.
And so he was in lifetime recovery, Judge. That's what he's requesting the court to give him the opportunity to prove himself, get back on treatment with lifetime recovery. Judge, I also have a letter from a Mr. Juan Trejo attesting to Mark's character, Judge. I don't know if you want to see that or not.
Oh, sure.
Okay.
Thank you. Thank you. So here's my question. I remember him. He's been before me previously, and previously it was a violation of 15G. He said that there were issues with ISF. I believe he said, I think either people were doing drugs or something else was going on in treatment. And, or either, no, someone was trying to fight someone, or they had Fight Club at the ISF. And I said, okay, we're going to check into that. And then what I ordered after he pled true to violation of 15G, I denied the motion, and it was the alternate mean conditions, and he was supposed to go to lifetime recovery. And people, it seems, are leaving lifetime recovery without telling me and leaving without my permission. So we need to start with, 1, why did he leave lifetime recovery? And 2, why shouldn't I revoke him and send him to prison? So that's where I am.
If I can, I'll have
Sure.
to answer the first question.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Mark Lewis.
All right.
Mr. Lewis, if you can tell the court why you left lifetime recovery the first time, sir.
I had gotten placed on a zero tolerance contract with my counselor. I was sent there by yourself, Your Honor, for the period of the 3-month program, and I was 2 weeks away from completion when placed on a zero contact order because somebody there had left a cell phone and they assumed it was mine. It wasn't, but that's beyond the point. I was on a zero tolerance order, and then I gotten in trouble, and somebody was cutting hair there, and they were cutting my hair, and they came and they said they're gonna write both of us up, and I took that to mean that they were going to violate the zero tolerance order. So I jumped to conclusions and I reacted wrong, and I left. I have no other excuse besides that, no other reason. That's what happened, and that's why that did happen. But I was doing the program, and I was 2 weeks from completion when all that happened, and everything just.
And what drugs have you been using since we have not seen you?
Honestly, I got back on IV usage of methamphetamine. I gotten really bad, like within 2 weeks of.
Oh, no, I can tell by your appearance.
Yes, ma'am. I gotten really bad within 2 weeks of there, and I really wanted to. I had found myself. I lost it.
All right, so here's the thing. I'm not sending him to lifetime recovery. He is going to safety, or either if felony drug court accepts him, he can be at felony drug court, but he is not going back to lifetime recovery. So those are his choices.
Judge, I would suggest that we go to safety first and give him the opportunity to go into treatment and get that done, Judge.
All right, anything else from either side? All right. Violation of condition number 4 is true. I'm going to deny the motion, alter and amend conditions to include safety, and we can refer him to felony drug court. I don't think they're going to accept him with the if there's a gang issue with him. He's to remain in custody until transferred to safety or felony drug court.
Your Honor, if he does not qualify for safety due to his sex offender registration, would the court consider state ISF again?
All right.
And Judge, I'm checking on that with our coordinator for safety to find out if they'll take it, if it's just registration and not the current offense.
Okay, so we'll do safety or felony drug court. If for some reason neither of those places will take him, we'll bring him back here and I'll consider something else. And he's to remain in custody until transfer. And there is going to be GPS, partial for treatment, any probation visits, and work only. If you come back here again, your fault, somebody else's fault, what's going to end up happening is they're going to file a motion to revoke and you're looking up to 6 years in prison. And this tier thing, not going to work.
And Judge, I did confirm they will not accept him at safety due to his registration requirements.
All right, we'll see if felony drug court will take him. If they do not, then, well, so you all want to come back. If felony drug court does not accept him, then state ISF, that's cognitive and substance abuse.
I only do one track.
All right, substance abuse track then. All right, is there anything else?
Not for that, no. Thank you very much.
You're welcome.
Maybe it's you, Your Honor?
Yes. Court is calling 2018 CR 9930, State of Texas versus Fernando Serrato. Could I have parties announced for the record for the state, for the defense?
Joseph Appelt.
And are you Mr. Serrato?
Yes, ma'am.
Yes. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Fernando Serrato who was placed on deferred adjudication in 2018 CR 9930 for the offense of burglary of a habitation force on April 17, 2019 for a period of 8 years? Is that you?
Yes, ma'am.
State? Oh, and I'm sorry. Also, did you review the state supplemental motion to enter adjudication of guilt and revoke community supervision?
Yes, ma'am.
All right, state, what allegations are you proceeding on?
Violation of condition number 13, Your Honor.
All right. Mr. Serrato, did you review violation number 13 with your attorney?
Yes, ma'am.
State is alleging that on or about the 11th day of February 2024 in Bexar County, Texas, the defendant Fernando Serrato did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13. How do you plead to that? True or not true?
True.
State, is that the only allegation you're proceeding on?
Waive and amend in the remainder, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 13?
Yes, ma'am.
Court will find violation of condition number 13 true. Is there a proposed agreement?
There is not an agreement, Your Honor.
All right, state, what are you requesting?
Guilt supervision, adjudicate guilt, assess punishment for 4 years.
We would respectfully request the minimum, Your Honor, 2 years. And if I may, Mr. Serrato is not a citizen. He has been previously deported. After conferring with Justin Tullius at our last setting on June 3rd, at length and in great detail regarding Mr. Serrato's situation, any possible defenses, et cetera. Mr. Tullius conferred with him, gave him certain bits of information and counseling advice. Mr. Serrato currently has a federal detainer on him from ICE. And so what we're requesting, Your Honor, is to revoke him and sentence him a minimum 2 years. That way he would get transferred over to the federal Department of Justice sooner and onto, in essence, their responsibility.
All right. Probation, has he done anything since he's been on probation?
No, Your Honor. Probation is recommending revocation. He was placed on probation April 17th of 2019, and he was transferred to ICE custody, and he was transferred to Honduras September 6th of 2019. We informed the court via supplemental report that he was deported, and February 11th, 2024, he had the 2 additional cases, and we were unaware when he returned back to Bear County.
All right, so correct me if I'm wrong. My understanding is he was deported
Correct, Your Honor.
and he came back to the United States.
Correct, Your Honor.
And I'm assuming, if I'm wrong, correct me, that he came back illegally.
Correct, Your Honor.
And then he came back and committed a new offense.
Correct, Your Honor.
And I understand driving without a license or with an invalid license. I understand we're not in felony territory.
Correct, Your Honor.
All right, this is what the court is going to do. The court is going to find you guilty and find 13 true. The court is going to sentence you to 8 years in the prison, give you credit for any time served, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, you do have a limited right to appeal. If that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes, ma'am.
All right, do not come back unless you're back legally. You understand?
Yes, ma'am.
All right, good luck to you.
May I be excused, Judge?
Yes.
Thank you.
This case wasn't just about one violation. It was about a pattern of broken chances, a defendant already on supervision, now back in court for failing to report. Judge Boyd listened as the violations were read, showing this was not the first time the system had dealt with him. The court heard excuses, but also saw a deeper issue, relapse and instability. What made it more serious was not just the violation, but the repeat. History Judge Boyd had already witnessed in earlier proceedings. He left treatment before completion, claiming confusion and misjudgment. But Judge Boyd made it clear this wasn't the first time trust had been broken in similar situations. That history made credibility harder to rebuild. In this moment, the emotional turning point came when the defendant admitted relapse and drug use. At that moment, the courtroom shifted from procedure to concern and frustration. Judge Boyd's decision reflected a balance between accountability and one last opportunity for treatment. Instead of immediate prison, structured programs were still considered under strict conditions, but Judge Boyd imposed clear limits. Due to prior failures and legal restrictions, the warning was unmistakable. Another mistake could trigger years in prison. This wasn't just a sentence decision. It was a final warning shot from Judge Boyd, and the real question left behind is whether another chance will finally be enough.